Next is trial of warrant and summons case. Okay. So first, if the case is instituted on police report, means you have filed an FIR. Please make a note.
Yes, ma'am.
Yeah. So 261. So when in any warrant case instituted on police report, the accused person appears or is brought before a judicial magistrate at the commencement of the trial, the judicial magistrate shall satisfy himself that he has complied with the provisions of section 230. Then section 262, the accused may prefer an application of discharge. Again same thing. Once the accused person is brought before the court and the trial begins, the accused person has the right or and liberty to file an application for discharge. Please underline. Application for discharge within a period of 60 days from the date of framing of charges. And if upon considering the police report and the document sent to it under section 293 and making such examination, if any of the accused as the magistrate thinks necessary, and giving the prosecution and the accused an opportunity to be heard, the magistrate considers that the charge against the accused persons are groundless, then he may discharge the accused and record the reasons for doing so. Okay. All same thing.
Yes, ma'am.
Whatever is for the session trial thing, same is for the warrant trial and summon trial case. Same thing are there, but only sections are bifurcated, and the court that will try is also bifurcated. Here only the chief judicial magistrate will have the power. Please underline or make a note somewhere. Next, section 263. So if upon such condition, examination, if any and the hearing, the magistrate is of the opinion that there is a ground for presuming the accused has committed the offence triable under this chapter, then such magistrate is competent to try and in his opinion could adequately punished by him. He can frame in writing a charge against the accused within a period of 60 days from the date of hearing on charge. The charge shall be read over and explained to the accused, and he shall be asked whether he pleads guilty of the offence charged or claimed against him. Same thing. Whatever is for session trial process, same thing is there, only difference is the sections.
Yes, ma'am.
Then section 264. So if the accused person pleads guilty, the magistrate shall record the plea and may in its discretion convict thereon. Same thing. If the person will plead guilty, then the magistrate then and there will pronounce the judgment or punish him. Now 265. So if the accused refuses to plead guilty or does not plead guilty or claims to be tried, then the magistrate will not convict the accused under section 264 and the magistrate will fix a date for the examination of witnesses. So if you don't plead guilty, then the court will begin the trial. It will start the trial to prove that whether you are guilty or innocent.
Yes, ma'am.
Now 266. The accused shall be called upon to enter upon his defence and produce evidence, and the accused puts in any written statement, the magistrate shall file it with the record. So if the accused after he has entered upon defence applies to the judicial magistrate to issue a process, please underline the word issue, any process for compelling the attendance of any witness for the purpose of examination or cross-examination or the production of any document or any other thing, the magistrate shall also issue a process unless he considers that the application should be refused on the ground it is made for purpose of vexation or delaying the or defeating the end of justice, and such ground shall be recorded by him in writing. So if the accused person wants to prove some document or produce some document and the document is with some other person, then the magistrate will also issue a process. Underline word issue, any process, to compel the attendance of any witness or to bring those documents to the court so that the guilt or the innocence of a person can be proved. Okay.
Yes, ma'am.
Any doubt?
No, ma'am.
Yeah. Next topic is cases instituted other than on police report. Please make a note. On complaint, on private complaint filed. Remember we studied what is complaint. Complaint is a tell.
Complaint. Yes, ma'am. Complaint is an allegation made to magistrate orally or in writing.
So here you are not writing to the police officer. Here you are directly writing to the magistrate. Okay.
Ma'am.
Yeah. So cases instituted other than on police report 267. So in any warrant case instituted or otherwise on the police report, the accused person appears or is brought before the magistrate. The magistrate shall proceed to hear the prosecution and take all such evidences as may be produced in support of the prosecution. The magistrate may, on application of the prosecution, issue summons to any of the witnesses directing them to attend or produce documents or anything. Hello?
Hello, ma'am.
Yeah, I think some network issue.
Yes, ma'am.
The magistrate may, on application of the prosecution, issue a summon to any of its witnesses directing him to attend or produce any of the documents. Now, section 268. So, if upon taking all the evidences that are referred under 267, the magistrate considers for the reasons to be recorded that no case against the accused has been made out, then if unrebutted would warrant his conviction, the magistrate shall discharge then and there. Same process is followed, only different sections are there. Okay. So now,
on complaint itself, the magistrate can arrest accused, ma'am.
What? Hello?
On complaint itself, the magistrate can arrest accused, ma'am, or after FIR only they should arrest?
No, in complaint case also they will arrest, but they will only arrest after taking the cognizance of an offense. You remember we studied cognizance of an offense,
Yes, ma'am. Yes,
framing
ma'am.
of charges. So if non-bailable charges are framed against him and the accused person is escaping or not coming to the court, in that cases the magistrate may order a warrant. Okay, warrant to be issued.
Yes, ma'am.
So nothing in this section shall deem to prevent a magistrate from discharging the accused person at the previous stage of the case, if for the reasons to be recording such magistrate he considers that the charge to be groundless. Then according to section 269, so if when such evidences have been taken or at any time previous stage of the case, if the magistrate is of the opinion that there is a ground for presuming the accused has committed the offence that is triable under this chapter, such magistrate is competent to try and which in his opinion could adequately punished by him, he shall frame in writing a charge against the accused. Please underline, he shall frame in writing a charge against the accused. The charge shall be read and explained to him, and he shall be asked whether he pleads guilty or wants to make a defense. So if the accused pleads guilty, then the magistrate shall record the plea and convict thereon. Next is the accused shall then 270, the accused shall be called upon to enter upon his defense and produce evidence, and the provisions of 266 shall apply to the case. So this is how the entire process is being carried out. Okay, any doubt? See, there is a repetition of same things again and again. Okay.
Yes, ma'am.
Yeah, so only difference is sections, because all the trials are mostly same. Okay. Yeah.
Yes, ma'am.